this miserable day. I'm sure we have some Zoom attendees. First, may I just start by acknowledging the traditional owners on the land on which we live, the Darug Nation, and pay my respects to the elders, past and present. It's my great honour and privilege today to present Judge Benjamin Zipser, Federal Circuit Court. Ben and I go back a little while. I was agreeing on the floor that he was already established, albeit by a year and a half earlier, but still my senior, but he was wonderfully generous. Now, Ben, you all have his abstract, I'm sure you've read it, and he's quite well known for having finished Bachelor of Commerce and Bachelor of Laws in 1992 and Bachelor of Civil Laws at the University of Oxford in 1996. He was an Australian government solicitor from 92 to 99, and from 99 to 2024, he practiced at the Sydney Bar and 5 Selborne chambers. He didn't change his chambers like I did. From 97 to 2004, he was lecturing here. But I don't know what it was. What was it you were lecturing? Torts law. And consumer protection. I don't know if we still have that, but still. As a result, he's also one of the co-authors of all 4 volumes or 4 editions of professional liability in Australia. And he was appointed in 2024 to the Federal Circuit Family Court of Australia Division 2 in its General Federal Law Division. He practices around Parramatta. So he's a local. But if I just, before handing the podium over, look, I just wanted to also just share one little bit about the judge that was noted in the Bar News when on his announcing his appointment. And apparently, and I'll concur with all of that. He's known for his powerful intellect and vast knowledge and experience. And he's also renowned for his humanity, compassion, personal decency, and altruism, which no doubt served him well for his appointment as a judge. So with no further ado, I present to you Judge Ben Zipser.
Section 75 of the Commonwealth Constitution defines the scope of the original jurisdiction of the High Court of Australia. Section 75(5) states, in all matters in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have original jurisdiction. Section 75(5) confers on the High Court power to review the legality of the exercise of statutory power by officers of the Commonwealth. This includes all persons who make decisions under Commonwealth legislation or statutes. Section 75(5) is a fundamental provision of the Australian Constitution and part of the bedrock of the Westminster system of government in Australia, since it is through Section 75(5) that the federal courts supervise the exercise of power by the federal executive under legislation enacted by the federal parliament. For comparative constitutional lawyers and other international law academics in the room, and the law school website suggests that there are a number of you at this law school, I challenge you to find a provision of a country's constitution worded in such boring and uninspiring language, and yet which is so significant. Judicial review of administrative action through Section 75(5) of the Constitution involves review by the federal courts of the legality of the exercise of power under federal or Commonwealth legislation. The High Court over the decades has set the boundaries for the lawful exercise of power. Where an administrative decision maker traverses those boundaries, the decision maker is said to have made an error of law, referred to more recently by the High Court since the 1990s as a jurisdictional error, and the federal courts may issue writs to quash the decision and remit the matter to the decision maker to determine according to law. As to the nature of the boundaries set by the High Court to determine the legality on review by the federal courts the exercise of statutory power by administrative decision makers. In the High Court decision of Craig v. South Australia in 1995, the High Court stated the following. The numbers in square brackets are mine. If an administrative tribunal falls into an error of law which causes it, 1, to identify a wrong issue, 2, to ask itself a wrong question, 3, to ignore relevant material, 4, to rely on irrelevant material, or 5, at least in some circumstances, to make an erroneous finding or to reach a mistaken conclusion, and the tribunal's exercise or reported exercise of power is thereby affected, it exceeds its authority of power. Such an error of law is jurisdictional error, which will invalidate any order or decision of the tribunal which reflects it. This list of categories of jurisdictional error was repeated by the High Court a number of times over the following 15 years. In a 2018 High Court decision of Hussain against the Minister, Justice Edelman referred to this list in Craig as, open inverted commas, the classic description by this court of the range of possible jurisdictional errors. In LPDT against the Minister in 2024, a full court of the High Court, comprising all 7 judges, stated that, or wrote, that jurisdictional error on the part of statutory decision maker in making a decision can include, and you'll then see listed 8 categories, which I've numbered from 1 to 8. Numbers 1 to 5 match with the 5 categories referred to in Craig. I can assure you that category number 6 has existed or been recognised as an error of law since the beginning of time, and category number 8 was recognised by the High Court as a category from about the 1980s. But it's category 7, exceeding the bounds of reasonableness, which is new. The focus of my presentation this afternoon is to consider the additional category exceeding the bounds of reasonableness, which I will call for this presentation the unreasonableness category. Issues I will address are: 1, when did the unreasonableness category emerge? When the High Court's decision in Craig in 1995, when it was not an established category, and in LPDT in 2024, by which time it was an established category. 2, is the unreasonableness category a new concept and thereby a new hit on the block? Or is the unreasonableness category a modern recognition of a long existing principle in Australian administrative law, and thereby a return of the Jenner? 3, what are the historical sources of the unreasonableness category? 4, what are the causes of the development of the unreasonableness category? 5, what is the scope of the unreasonableness category? 6, what are the implications of the unreasonableness category for administrative decision makers? And 7, what are the implications of the unreasonableness category for judges hearing judicial review applications? To understand when the unreasonableness category emerged in Australia, it is necessary to understand a distinction between where decision makers exercise powers under legislation: 1, the making of findings of fact, and 2, the exercise of discretionary powers. A section of the Migration Act which conveniently involves a consideration of both concepts is section 116(1)(e) Roman numeral 1 of the Migration Act, which appears on the slide on the right. Whether the Minister is, open inverted commas, satisfied that the presence of a visa holder in Australia is or may be ... a risk to the health, safety or good order of the Australian community involves a finding of fact concerning the Minister's satisfaction. The High Court has sometimes referred to this finding of fact as an evaluative fact, since the finding requires evaluation of a number of matters. The High Court has also referred to this fact as a jurisdictional fact, because the jurisdiction of the decision maker to exercise power requires satisfaction of fact. If, but only if, the minister is satisfied of the jurisdictional fact, it becomes open to the minister, not necessary, but open to exercise a power to cancel the visa. Where the jurisdictional fact is satisfied, the power to cancel the visa is enlivened. The power to cancel the visa is a discretionary power conferred by the word may. In summary, whether the minister is satisfied of the matter referred to in 116(e)(1)(e) concerning satisfaction involves a finding of fact, and where that jurisdictional fact is satisfied, whether or not the minister decides to cancel the visa involves the exercise of discretionary power. In relation to judicial review of the making of findings of fact by decision makers exercising power under legislation, the High Court decision in which a majority recognised the unreasonableness category for the first time was Minister for Immigration and Citizenship versus SZNDS in 2010. It is desirable to explain some aspects of the administrative decision to appreciate the significance of the High Court's decision. The Federal Parliament in the Migration Act has empowered officers of the Federal Executive to grant visas to non-citizens, including protection visas. Section 65(1) of the Migration Act provides, after considering a valid application for a visa, the minister or a delegate of the minister, if satisfied that the criteria for the visa prescribed by the Act or the regulations have been satisfied, is to grant the visa, or if not so satisfied, is to refuse to grant the visa. Thus, Section 65 of the Act requires a decision maker to grant the visa if satisfied that all criteria for the visa are satisfied, but to refuse to grant the visa if any criteria is not satisfied. Section 36, subsection 2A of the Act provided at the time of the decision maker's decision for protection visas that a criterion for a protection visa is that the applicant for the visa is a non-citizen in Australia to whom the minister is satisfied Australia has protection obligations under the Refugees Convention. Pursuant to the terms of the Refugees Convention, Australia had protection obligations to persons who had a, open inverted commas, well-founded fear of being persecuted for reasons of race, religion, nationality, ... So, an evaluative fact for the decision maker, which made a difference as to whether they could or could not be granted a protection visa, was whether the decision maker was satisfied that the applicant had a, open inverted commas, well-founded fear of being persecuted, close inverted commas, in their country of nationality. The applicant, a citizen of Pakistan, claimed that he was homosexual, that homosexuals were persecuted in Pakistan, and therefore if he returned to Pakistan, he faced a real chance of persecution. The decision maker, which was the Refugee Review Tribunal, accepted that homosexuals were persecuted in Pakistan, but did not accept the applicant was homosexual. In summary, the applicant gave an account of his personal history, including that he developed an attraction to members of the same sex, engaged in homosexual activities while living in the United Arab Emirates between 2005 and 2007, and the tribunal made a finding of fact, refusing to accept that the applicant engaged in such homosexual activities. Imagine you were the tribunal member. Section 430 of the Act requires tribunal members to give written reasons for their decisions, which must, among other things, open inverted commas, set out the findings on any material questions of fact, close inverted commas, and open inverted commas, refer to the evidence or any other material on which the findings of fact were based, close inverted commas. The tribunal's written reasons for decision recorded two reasons that the tribunal member rejected the applicant's account of engaging in homosexual activities in the UAE. A judge of the Federal Court found that the decision maker's rejection of the applicant's account was based on illogical or irrational findings or inferences and quashed the decision. On appeal to the High Court, all 5 judges of the High Court recognised for the first time that, open inverted commas, illogicality or irrationality may constitute a basis for judicial review in the context of jurisdictional fact-finding. Two judges went on to find that the tribunal's rejection of the applicant's claims was not supported on logical grounds, and therefore the tribunal's state of satisfaction was infected by jurisdictional error. But the majority of three judges found that a logical or rational decision maker could have come to the same conclusion in not believing the applicant's claims, and therefore there was no jurisdictional error. Importantly, the finding of fact, which may be illogical or irrational, for this ground of jurisdictional error to be established, is not limited to the ultimate evaluative finding of fact, in this case with reference to section 36 subsection 2A of the Act, whether the decision maker was satisfied that Australia has protection obligations under the Refugees Convention to the visa applicant. The finding of fact which may be challenged or impugned includes, open inverted commas, findings on the way to, close inverted commas, the ultimate decision, or, open inverted commas, findings upon which that decision was based, close inverted commas. Those two quotes are taken from SZNDS. In considering whether a criterion for a visa is satisfied, decision makers must make intermediate findings, often many intermediate findings, which become building blocks on which the ultimate finding as to whether the criterion is satisfied is based. Thus, the ultimate finding of whether a visa criterion is satisfied will often be based on a number of, and sometimes many, intermediate findings. SZNDS opens the door, or opened the door, which remains open, to applicants who have been refused visas, challenging the rationality or logicality of the reasoning process in support of each intermediate finding. In relation to the exercise of discretionary powers in legislation by administrative decision makers, the High Court decision which clearly recognised the unreasonableness category for the first time was Minister for Immigration and Citizenship against Lee, decided in 2013, which was 3 years after SZNDS. Again, it is desirable to explain some aspects of the administrative decision to appreciate the High Court's decision. In February 2007, a visa applicant applied for a skilled independent student visa. Section 65, which I've referred to before, required a decision maker to grant the visa if satisfied that all criteria were satisfied, but to refuse to grant the visa if any criteria was not satisfied. One criterion, which is on the slide in the bottom left of the visa, was that a relevant assessing authority has assessed the skills of the applicant as suitable for his or her nominated skilled occupation, and no evidence has become available that the information given is false or misleading in material particular. By the date of her application, the applicant had obtained a skills assessment from the relevant assessing authority, Trades Recognition Australia. In a decision made in about December 2008, the department refused to grant the visa on the basis that some information the applicant provided to TRA was not genuine or false or misleading. The applicant's position was that her former migration agent provided the incorrect information to TRA without her knowledge. She then applied to the Migration Review Tribunal for review of the department's decision. In December of that year, the tribunal convened a hearing. The applicant's new migration agent told the tribunal at the hearing that the applicant was awaiting a decision of TRA with respect to an application for a fresh assessment of her skills from TRA, but this time based on correct information, so the information would no longer be false or misleading, which, if successful, would enable the tribunal to find that the skills assessment criterion in the bottom left corner of the slide was met. The applicant had not yet received the first skills assessment by the time of the hearing. Following the hearing, the tribunal invited the applicant to provide further information by 18 January 2010, which was about a month later, so she had about 28 days, and within that time, the applicant's agent informed the tribunal that the fresh skills assessment had been received, but it was not favourable. According to the agent, the TRA had made two fundamental errors. The applicant had applied to TRA for a review of its assessment in light of the two fundamental errors, and the agent requested that the tribunal forbear from making any final decision regarding the review application until the outcome of the fresh application to TRA is finalised. Section 363(1)(b) of the Act, on the right hand of this slide, stated, for the purpose of the review of a decision, the tribunal may adjourn the review from time to time. The agent effectively was asking the tribunal to exercise its procedural power to adjourn the review until the applicant obtained the updated skills assessment. Imagine you were the tribunal member. Would you accede to the applicant's request? 3 years had passed since the applicant applied for the visa, yet she was still asking the tribunal to give her more time to obtain a skills assessment. And if you would not have given her more time, why not? What would you have said in your reasons for the decision? The tribunal did not accede to the agent's request, but instead made a decision on the review a few days later, which, since the criterion in the bottom left corner clearly was not satisfied, involved refusing to grant the visa. In relation to the agent's request to forbear from making a decision until the outcome of the skills assessment was finalised, the tribunal wrote in its reasons for decision that, open inverted commas, it considers that the applicant has been provided with enough opportunities to present her case and is not prepared to delay any further, close inverted commas. The question for the High Court was whether the tribunal's decision not to exercise its procedural power under 363 to adjourn the review until the skills assessment was finalised involved a jurisdictional error. In relation to this question, all 5 judges stated that, subject to consideration of specific statutory schemes, all statutory powers and discretions must be exercised reasonably, and all 5 also concluded that the tribunal's refusal to adjourn the review as requested by the applicant's agent on the particular facts of the case was legally unreasonable. I do not have time in this presentation to explain the High Court's reasoning process as to why the tribunal's refusal to adjourn the review was legally unreasonable. Suffice it to say that this was a remarkable decision, and again opened up the doorway for discretionary decisions to be challenged on grounds of legal unreasonableness. Views of commentators will differ as to whether the unreasonableness category is a new concept and thereby a new block, or a modern recognition of a long existing principle in Australian administrative law and thereby a return, whichever. In my view, as a result of the High Court's decisions in SNMDS and Lee, the unreasonableness category is a new block. Prior to those decisions, other than in extreme cases, a lawyer briefed for an applicant in a judicial review application could not have exceeded on an argument based on unreasonableness in the exercise of power or illogicality or rationality in a reasoning process leading to a finding concerning a jurisdictional fact. While the unreasonableness category is a new block, for reasons I've explained, as is not uncommon, the High Court in SNMDS and Lee traced the source of the category to earlier High Court decisions. The subcategory of unreasonableness, illogicality or rationality in fact finding, SNMDS traced the subcategory back to decisions of the High Court in the King and Connell ex parte and Belbert Collieries Limited and Avon Downs Proprietary Limited against the Federal Commission of Taxation, where in the context of the statutory scheme which empowered a decision maker to act when satisfied of the state of affairs, Justice Dixon stated that, open inverted commas, if the result appears to be unreasonable, close inverted commas, then the decision maker's conclusion is liable to review. And a full federal court decision a few years later traced the source back even further to a decision of the High Court in Blue Coat Bay Company Limited against the Commonwealth, where Justice Stark stated as far back as 1927, open inverted commas, so long as the minister acts on circumstances giving him a rational ground for the belief entertained, then the courts of law cannot and will not interfere, close inverted commas. For the subcategory of unreasonableness in the exercise of statutory discretionary powers, in Lee, the plurality traced the subcategory back to a House of Lords decision in Sharpen Wakefield in 1891, where Lord Halsbury, after referring back to the 1597 decision of an English court in Rook's case, stated that the discretion of commissioners of sewers, open inverted commas, ought to be limited and bound with the rule of reason and law, close inverted commas, and they also referred to the Queen and Anderson ex parte Air Proprietary Limited, where Justice Keto, paraphrasing Sharp and Wakefield stated that, open inverted commas, the discretion allowed by statute to the holder of an office is intended to be exercised according to the rules of reason and justice, close inverted commas. In light of the various references in High Court decisions in the 20th century to reasonableness and rationality as a condition, the exercise of statutory powers by administrative decision makers, it could be said that rationality and reasonableness in the exercise of statutory powers is a Jedi principle rooted in the common law, like Jedi powers are rooted in the Star Wars universe. And thus, the unreasonableness category marks the return of the Jedi. It's unclear why the High Court recognised the unreasonableness category with SZMDS in 2010 and Lee in 2013, in contrast to recognising the category decades earlier or not recognising the category at all. Some ideas for causes of the development of the unreasonableness category in SZMDS are near as follows. First, in SZMDS, two judges suggested that the contemporary indication of illogicality and irrationality as a basis for judicial review first emerged in Australia as a reaction to the ouster of the review ground of Wednesbury unreasonableness in the Migration Act. I don't have time to explain this in detail, but in short, in 1992, Parliament, through an amendment to the Migration Act, attempted to limit the grounds on which the federal court could review decisions under the Migration Act. One limit was to exclude review for Wednesbury unreasonableness, which is a concept that people of my generation may recall learning about in administrative law at law school. The suggestion in NZMDS is that this ouster by Parliament caused some High Court judges, in opposition to Parliament's intention, to commence developing illogicality and irrationality as a basis for judicial review. A second idea is as follows. SZMDS was handed down in May of 2010. In February 2010, 3 months earlier, the High Court handed down a decision of Kirk, the Industrial Relations Commission, which I expect a number of you have heard of. The pluralities judgment, joined by 6 of the 7 High Court judges, contained a seminal discussion of the concept of jurisdictional error. The judgment quoted with approval an observation of Louis Jaffe, a Harvard Law School public law scholar, written in an article published in 1957, that denominating some questions as jurisdictional is entirely functional. It is used to validate review when review is felt to be necessary. If it is understood that the word jurisdiction is not a metaphysical absolute, but simply expresses the gravity of the error, it would seem that this is a concept for which we must have a word, and for which use of the hallowed word jurisdictional is justified. Their Honours in the High Court added at paragraph 71 that, open inverted commas, it is neither necessary nor possible to attempt to mark the metes and bounds of jurisdictional error, close inverted commas. As stated by the authors of the equally seminal textbook by Mark Aronson and others, Judicial Review of Administrative Action and Government Liability, in Kirk, the High Court, open inverted commas, loosened the bolts, close inverted commas, of the standard grounds of review, and thereby opened the way a few months later to develop, or more easily develop and recognise, the unreasonableness category. A third suggestion is as follows. In Australia, there is no common law obligation for decision makers who make decisions under legislation to give reasons for their decisions. From about the mid-1970s, there was a gradual recognition by parliaments in Australia, state and federal, of the utility of requiring decision makers to give reasons. This led, slowly, to the introduction into various statutes of a statutory obligation on decision makers to give reasons for their decisions, including was introduced into the Migration Act in the early 1990s. As ZMDS and Lee indicate, the unreasonableness category focuses on a decision maker's reasons for finding a fact or an exercise of a discretionary power. The prevalence by 2010 of statutory obligations on decision makers to give reasons for their decisions, including the Migration Act, may have contributed to the High Court's decision to develop the unreasonableness category when it did. And a fourth idea is as follows. In Kiowa and West, the High Court developed the principle in 1985, initially expressed in the judgment of Justice Brennan, that, opening inverted commas, the legislature intends the principles of natural justice, which we now call procedural fairness, to be observed in the exercise of statutory powers in the absence of a clear contrary intention in statute. And therefore, the legislature's intention is that observance of the principles of natural justice is a condition of the valid exercise of power. And by that judgment, the High Court was recognising the obligation of procedural fairness as, at that time it was implied by the common law. Some judges said it was implied by common law, by statute. The view now is it's implied by statute, but it became a broad-based category of jurisdictionality. From about the commencement of the 21st century, the federal parliament attempted, in the Migration Act, to replace the broad obligation on decision makers to accord procedural fairness with statutory codes designed to control and limit the obligation of procedural fairness on decision makers. It is possible that the High Court's development of the unreasonableness category in Lee was a reaction to Parliament's attempt to control and limit, in the Migration Act, the obligation of procedural fairness. For two of my four suggested causes on this slide, the cause involved a reaction by the High Court to legislation passed by the Federal Parliament. Just as the Star Wars universe involves a never-ending battle between two sides of the Force, so too the Westminster system of government involves not infrequent battles between the three different branches of government. Of particular interest to practicing lawyers is the scope of the unreasonableness category. There are many points one could discuss about the scope. For time reasons, I will limit myself briefly to 6 points. The first point is to explain subcategories of the unreasonableness category, and I'll identify on this slide 4 subcategories. One subcategory in the top left is legal unreasonableness in exercising discretionary procedural powers, and case of Lee involved a discretionary procedural power, which I've discussed. A second subcategory in the top right is legal unreasonableness in exercising discretionary substantive rather than procedural powers. And I return to section 1161E of the Migration Act and the discretionary power of the Minister to cancel a visa is a substantive power. You may recall the full federal court decision in Djokovic against the Minister in early 2022. The case is hard not to recall since we were all stuck at home in January 2022 with nothing else to do other than to follow the Australian cricket and related news. The Minister exercised this power to cancel Mr. Djokovic's visa on the basis that his presence in Australia may be, to track subsection E, a risk to the health, safety and good order of the Australian community. The full federal court considered whether the minister's exercise of the discretionary substantive power was legally unreasonable, and even if you haven't read the decision, since you all know that Djokovic did not play in the Australian Open, you can infer he lost the case. A third subcategory in the bottom right is legal unreasonableness in fact finding, example is SNMDS. And the fourth subcategory, which is part of the third subcategory, but with a difference, with some differences, is legal unreasonableness in fact finding concerning credibility. Where a decision maker under the Migration Act, after questioning a visa applicant at an interview or hearing, rejects the applicant's claims as not believable. The position at the start of the 21st century, so not that long ago, was encapsulated by the one-line zinger of Justice McHugh in Re the Minister Ex Parte Jure Rajasingam, that, open inverted commas, a finding on credibility is the function of the primary decision maker par excellence, close inverted commas. And that one-liner was used or referred to by a number of federal court judges to effectively say that credibility findings were all but immune from challenging judicial review proceedings. Following the development of the unreasonableness category, decisions concerning credibility are no longer immune from challenge in judicial review applications. The courts will carefully consider the decision maker's reasoning process leading to the adverse credibility finding. A second point is that there are, in considering the scope of the unreasonableness category, is that there are both overlaps, but also differences or distinctions in principles applicable to the four subcategories. For this reason, in any particular case, it is necessary to be aware of the subcategory as subject to the judicial verification. A third point is that where the decision maker gives reasons for their finding of fact or discretionary exercise of power, the subject of challenge in a judicial review application, careful consideration must be given to the decision maker's reasons. As stated in the High Court decision of Minister against SZVFW, open inverted commas, where reasons are provided, they will be the focal point, close inverted commas, of an assessment of whether the decision was legally unreasonable. A fourth point connected to the third point is as follows. In Minister against Lee, the plurality stated that, open inverted commas, unreasonableness is a conclusion which may be applied to a decision which lacks an evident and intelligible justification, close inverted commas. The concept of evident and intelligible justification has been picked up in subsequent High Court and Federal Court decisions as a useful marker for whether or not an exercise of discretionary power or a finding of fact is legally unreasonable. It's not determinative, but it's for practitioners trying to trying to work out whether a finding of fact or exercise of power is legally unreasonable. It is a useful tool to use. And for example, in SZVFW paragraph 84, two justices stated that it would be a rare case to find that the exercise of a discretionary power was unreasonable, where the reasons demonstrated an intelligible justification for the exercise of power. A fifth point, again as stated in Minister against SZVFW, is that legal unreasonableness is invariably fact-dependent and requires a careful evaluation of the evidence. The result is that in court proceedings, while legal principles remain the same, the result of one case is in no way an indicator of the result of another case, because each case will turn finally on the facts and the reasoning process by the decision maker. A sixth point is that when considering legal unreasonableness in the exercise of procedural or substantive discretionary powers, as stated in the Minister against Lee at paragraph 67, it is necessary to look at the scope and purpose of the statute conferring the discretionary power. Subsequent High Court and Federal Court decisions, which have considered legal unreasonableness in the exercise of procedural or substantive discretionary powers, have carefully considered the scope and purpose of the statutory provision conferring the discretionary power, because it's an important consideration in determining whether the exercise of power was legally unreasonable. Some observations concerning the implications for administrative decision makers arising from the development of the unreasonable category are as follows. I have to add lib from here because I seem to have left pages. The main, as I recall from what I wrote, the main observation is that there is a greater burden, the development of the unreasonableness category places a greater burden on administrative decision makers. Because, for example, if you think back to what I said about SZMDS, for each intermediate finding of fact, they need to provide, or SZMDS places perhaps some form of pressure on them or encouragement on them to provide a reasoning process to support the intermediate finding. It may not have to be detailed, but still a reasoning process, because it may be subject to challenge on a judicial review application, and equally when decision makers exercise discretionary powers, either procedural or substantive, they should think carefully about the reasons for the exercise of power, and they should be encouraged to record those reasons in their written decisions, so that their decisions are defensible on judicial review applications. So that's the main implication on administrative decision makers. And in a similar manner, the main implication of the unreasonableness category for judges hearing judicial review applications is, as has been recognised in some federal court decisions, just as there is a greater burden on administrative decision makers, there is also a greater burden on judicial officers, because on any occasion when a reasoning process to support a finding of fact or a discretionary power is challenged, careful consideration must be given to the statutory context, the reasons given by the decision maker, and the underlying fact. And I think, what's next? Concluding remarks, great. So, we return to section 75(5) of the Commonwealth Constitution. Judges of my court hearing migration matters have to consider issues arising under section 75(5) on applications to the Migration Act every day, considering the Jedi-like balance between the three arms of government in the Westminster system. I then say to any students, are there any students in the room today?
Yep.
Not today?
No, we do have one student.
One student. Any students here or students listening that by coincidence there are currently one or two vacancies for deputy associate positions at the court. For the current vacancies, the applications close on the 5th of August, and for the the one student here. I've brought along two amazing current associates from court. Liz, who works in the chambers of a family law judge, and Emily, who works in my chambers, general federal law, and you at the back are welcome
Anthony.
to speak with both of them if you're interested in learning more about associateship positions. And finally, I thank Dr. Azzi for inviting me to speak today.
Please thank It was very reassuring that accountability of government is certainly not forgotten. We have, 10 minutes for questions. We'll make it 15 minutes. Any questions? Are you prepared to take some questions? But thank you for that very enlightening, very thorough talk. Yes, Rayhan.
Thank you so much. That was terrific. Just wanted to ask a little bit more about Wednesbury, because as you started your talk, I was like, oh, this just sounds like Wednesbury unreasonableness in another form. But then as your talk progressed, it seems like what you're describing here is something that's more intrusive and more robust than Wednesbury. At least as I understand Wednesbury, which, at least as originally articulated, was the decision has to be so unreasonable that no sane person would basically make the decision.
Yes, the public law, the administrative law commentators, following the development of legal unreasonableness by the High Court recently, describe Wednesbury unreasonableness as a lunacy standard. And it's commonly acknowledged both by the High Court and by the commentators that the standard of legal unreasonableness is more intrusive or a lower threshold. A question which where there's not yet a conclusive answer by the High Court is where exactly that threshold is. And so, for example, in Lee, if you look at the different judgments, the judges used different language in their attempt to describe the threshold, and it's impossible to use precise language to describe the threshold. There are words used like stringent, which was a word used by Chief Justice Kiefel in Lee, but then what's stringent to one person may not be stringent to another person. I've a test that I feel comfortable with, or that resonates with me, is the intelligible and evident justification test. It's not the only test, but if a reasoning process does have an evident, intelligible justification to the person reviewing, then it'd be hard for an applicant to persuade the court. Does that answer your question?
Can I just add that? I want to get your insights on that. Sorry if I can jump on that. In SNMDS, Justice Crennan and Bell talked in language that Wednesbury unreasonable said, like, it's not irrational if another tribunal member would find, if you can find logicality, if someone else can find rationality. They're trying to hark on back to the Wednesbury unreasonableness. Now, the way you say, and I think I agree with you, is that's gone by the by, hasn't it? It's like looking for some, if there's another tribunal member who would have reached that decision, no longer applies.
I think yes, that you'll have some judgments which will say, where the judge will say, with reference back to Wednesbury, the court considered that it was clearly open to another decision maker to arrive at this finding or exercise this power. So that harks back to the Wednesbury language. But in general, the Wednesbury language it's no longer
Yeah, I agree.
controlling, and also irrationality or illogicality can appear in many forms. And for example, the types of cases where, as some commentators have acknowledged, that the full federal court has done quite a bit of the heavy lifting in this area, following the High Court decisions, but there are some very interesting full federal court decisions. And one type of case where the full federal court, they're just some really interesting decisions. Under Section 501 of the Migration Act, visas can be cancelled on character grounds, and where the power to cancel is usually enlivened with the person who's not an Australian citizen is sentenced to a term of imprisonment of 1 year or more. And you might have, there are cases where people arrived here as children, have lived here for many years, but have committed one or criminal offences. And the decision makers need to make difficult decisions balancing the interest in the safety of the Australian community with the interests of the individual. And there are some cases where the decision maker will make a finding as to, finding that there is a risk that this person will commit a further offence if they're permitted to stay, and the federal court is very carefully looking at the reasoning process leading to that finding, and that is well beyond the lunacy test, because I can't explain it in any more detail, but it's just well beyond, far more intrusive.
Thank you. Any further questions? Yes, madam.
Thank you. I'm not an administrative law teacher or researcher, so my question might not even be phrased properly, but two sort of interrelated things. So if what happened in this case is sort of extends the standard of review, has there been government discomfort with that extension? And if so, is there any chance that there will be legislative action?
Well, good question. Very good question. The government, there has been one could say a battle between government and the High Court, and in general, I think the High Court has won. The greatest battle was occurred in around 2001. It was around the time when the Tampa sailed over the horizon. I just can't remember if it occurred before or whether Tampa was used as a justification, but the Howard government introduced a privative clause into the Migration Act. It's a section of the Migration Act which is designed to deprive the courts of jurisdiction to review the administrative decision. If a privative clause did have full effect, then effectively the decision maker's decision is immune from challenge. There was a couple of years between about 2001 and 2003 when federal court judges and practitioners, and I was one of those young people at the time, were trying to sort of work our way around the privative clause without much effect. And then in 2003, the High Court handed down a decision that overcame, sidestepped the privative clause. So that's an example of a difference of view between the executive and the High Court, and the High Court has used Section 75(5) of the Commonwealth Constitution to develop the concept of jurisdictional error, and effectively it's not immune from restriction by legislation, but in general attempts by some governments to control or restrict the grounds have not succeeded. Does that answer your question? One observation is, although there is a much greater burden on administrative decision makers, which does increase costs, including for taxpayers, it also improves the quality of decision making, and that's, I think that's positive.
Look, I take the time, and unless we've got a really pressing question, can I just wrap it up and ask you again to please I know there's a 1:30 meeting as well, so I'm realising we're going over time, but thank you.
I know. I thought about it, I couldn't take it up much.
Yeah, what? I don't know what that is.